Let's test your knowledge of intellectual property rights. On the screen, you see 4 folders. You see 1 for a logo, 2 for a recipe, and 3 for an invention, and 4 for a brand name. Can you tell me what intellectual property right applies to each one of these? Oh, and can you tell me if more than one intellectual property right applies to any of these? In this video, I'm going to discuss the difference between copyright, trademark, patent, and trade secret protection. And I'll also discuss if any of these overlap in any scenarios. My name is Elizabeth Seltzer, and I'm an intellectual property attorney with over 30 years of experience assisting businesses of all sizes in navigating trademark and copyright issues. On this channel, I break down complex legal issues into practical guidance that you can actually use to assist your business. This channel is for general educational and informational purposes only and does not constitute legal advice. Viewing this content does not create an attorney-client relationship, and laws vary by jurisdiction. One of the biggest misperceptions I always see is that people use certain intellectual property rights interchangeably. But each type of intellectual property right protects something differently. Copyrights protect creative expression, whereas trademarks protect a brand identity. Patents protect inventions, whereas trade secrets protect confidential business information. Understanding the difference between all of these protections is important because applying the wrong protection can leave certain assets exposed. So let's first discuss copyrights. Copyrights protect original works of authorships fixed in a tangible medium of expression. So think of things such as photographs, videos, written content or music or artwork. Think of software content, website content, things that are expressed in a tangible medium of expression. So copyright protection exists once the work is created and fixed in that tangible medium of expression. So copyright registration is not necessary. However, it's advisable and very important to provide certain benefits afforded by such registration. So one of the key takeaways here is that copyright protects the actual expression in that fixed tangible medium. It doesn't just protect ideas or notions. Trademarks, on the other hand, protect identifiers that tell consumers the source of certain goods and services. So trademarks can protect things such as brand names, logos, slogans, packaging, and even colors or product design in some situations. The ultimate purpose of trademark protection is actually to protect the consumers to prevent what's called consumer confusion. How to acquire trademark rights? Well, trademark rights in the United States are acquired through what's called use in commerce. It's not the act of registering a trademark that gives it the protections afforded under the trademark laws. However, as with copyright registration, trademark registration does afford a list of benefits, and it's advisable to seek federal registration if possible. And unlike copyright registrations, a trademark registration and protection can last indefinitely if it's continued to be used in commerce, and as from the registration perspective, that registration is actually maintained. So patents protect inventions and technological innovations. There's different types of patents. There are utility patents, design patents, and there are even patents for plants, known as plant patents. So patents give the owner the right to exclude others from making, using, or selling an invention for a limited period of time. However, unlike copyright and trademark rights, patent protection generally requires filing and approval before protection actually exists. And public disclosures of the underlying technology or invention can cause a lot of issues if done prior to filing for patent protection. So timing is enormously important. So trade secrets protect valuable, confidential business information. So that might include certain formulas or customer lists or manufacturing methods, maybe pricing strategies, internal processes of a particular company. A crucial issue for trade secret protection is the maintenance of secrecy. If certain information, processes, or data or methods is revealed publicly, well then that information may lose the benefit of trade secret protection. As far as the duration of protection, the trade secret protection can arguably last as long as the secrecy is maintained. So here's where things get interesting. More than one intellectual property right may apply to an asset. In fact, they may overlap and really lock down protection for a particular asset. I'm throwing out a few examples. A logo may be protected by, well, first, by copyright as an artistic work, and then secondly, it can be used, if it is used as a trademark, it can potentially be covered by trademark protection. A product design might be covered by a utility patent for its function. It could potentially be covered by a patent for its design. And it could also potentially be covered by a trademark as trade dress for its design. A common issue that often is discussed online and among creators is whether or not a recipe is subject to any type of intellectual property protection. So the written cookbook text may be copyrightable. The brand name may function as a trademark, and the actual formula of a particular recipe, if maintained as a secret, could qualify as a trade secret protection. But obviously that wouldn't apply if it's written and open to the public. But let's think along the lines of some companies who have very coveted secret formulas for certain soda brands. This is why intellectual property strategy includes analyzing whether or not various intellectual property rights can apply to certain assets, and maybe more than one of those intellectual property rights can apply to your assets. So here's a list of some common business mistakes that people make about intellectual property. They rely on copyright when they really need trademark protection. They disclose inventions to third parties before even considering patent protection. They fail to maintain proper confidential information. They assume registration automatically covers everything. As noted earlier, each intellectual property serves a different legal purpose. So the key at the onset is to understand what you're trying to protect and choosing the right legal tools to protect it. I realize this video is just very general information, so if you want to hear specifics about certain intellectual property rights, let me know in the comments. I also will give a caveat. I am not a patent attorney, so I am not in a position to give any detailed information about patent information. I do handle copyright, trademark, and trade secrets, so I'm happy to make a future video about any one of these. However, again, with the caveat that I'm not providing legal advice, this is just general information. If you do want specific legal assistance, I will leave a link below in the description so that you can reach out to my law firm and request us to work with you. I look forward to hearing from you, and thanks so much for watching.